Hey, y'all. Y'all, we back on day 4 of the Memphis pastor murder trial. Day 4. Yes, is she guilty? Make sure you like, share, and subscribe to the channel. Now, this video is for the purposes of education, commenting, criticism, entertaining purposes. Now, just to give y'all a little boost out, what's going on here? She fell in love with a pastor. Yes, she did. He promised her a lot of things. Yeah, he promised her a lot of things, and she was looking forward to being with him. So she decided to make a decision on her own. So y'all sit back, relax, and some things in the trial I'm going to skip to keep, so I can have a good video so y'all can always go back and watch it. So some things you're not going to be able to hear. Okay? All right, y'all. So tell me, is she guilty or is she not guilty of murdering the Memphis police? No, I said Memphis. Tell me, is she guilty or not guilty of murdering the Memphis pastor in 2019? All right, y'all. Enjoy.
And I made one more correction um, on the criminal attempt first degree murder. And I think she sent that out to you. Well, were there any corrections or anything from what the parties saw? I did, Your Honor. I don't know if the wants to go first. I just have one issue that it's always been something I haven't understood. So when the definitions of intentionally and transferred intent is in second degree murder, but not in first degree murder, and I don't understand why that is. Yes. Right. And so my position is that language should be in the charge for murder one because it is a criminal attempt murder one. It doesn't affect criminal attempt second degree murder. Just second. Well, so yeah, so I don't. The transfer intent element is so the criminal intent. By the time you get there, the court is saying I've already defined. I changed it. Oh, did you? I did. Okay. Because the criminal attempt for serious violent injury, I included. I want to make sure she said she had the correct contract. And she may have. We got a corrected one last night. Okay. It's or this morning.
So y'all, they changed something. Something changed. I wonder what changed. Okay, let me put it back right here. Let me see. I tried to skip a little bit, but it came up too fast. Hold on for a minute. Right here. Put it right here.
Do you have a car? And do you have a clean driving record? Did you know you could pay as low as $19?
It's the same courtroom Hernandez was in.
Okay. Did you have anything else? No, ma'am. Okay, all right.
I just note my objection to the change.
Okay. Did you have any other changes to these?
Yes, Your Honor.
Okay.
On page 2, this is a unique situation in that it's the last paragraph, sentence of the paragraphs regarding first degree and criminal intent first degree. It says that Latasha Daniels pleads not guilty to every count as encompassed. To every charge as encompassed. And we are not saying that she is not guilty of all of those offenses. We are saying that she is not guilty of first degree murder. She is not guilty of second degree murder. That this is at best a voluntary manslaughter. So I would like to take that language out, or at least change it to has pled guilty to the originally charged offense, or something along those lines.
Which part are you talking?
It's page 2. It's the last sentence.
Defendant please not guilty to each and every offense and person. You just want to take it out completely on each one of them?
Yes.
Okay, that's fine.
Peter, be quiet.
Any objection from the state? No, ma'am. Okay, yeah, I can take that out. No problem. Anything else?
Yes, Your Honor. Regarding the section on defendant testifying, it's on,
No, they're not numbers. Let's see.
It's after direct and circumstantial evidence.
Okay, defendant testifying, yes.
Your Honor, I would just ask, it does say like subject to all of the rules that apply to judging the credibility of other witnesses. I would just ask that
Hey, Sam.
it be made clear that just like with other witnesses, the law presumes that a testifying witness is telling the truth, and to be given a full and fair consideration. I mean, really that first paragraph of credibility of the witness, minus all of the factors that they need to look at, I would suggest adding into that defendant testifying so that it's clear that the same rules apply for Ms. Daniels as applied to all of the other witnesses.
So what are you suggesting? Yeah, what language are you suggesting?
If you go to, so it's kind of cross-referencing, if you go to the credibility of the witness,
Okay,
that's 25 pages in. That first paragraph that says, if there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important their testimony was. You do not have to accept that basically that whole first paragraph for the credibility of the witnesses. But particularly the fact that the law presumes that witnesses are testifying truthfully if the jury can find them. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. Just because it's one says witnesses and one says defendants, so I want to make clear that the defendant is a witness that also has the presumption that they are telling the truth.
Okay, so the language specifically that you want to add is, I want to make sure I have that clear.
If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth.
And then, her credibility is determined by the same rules of credibility of other witnesses determined. So you just want to add that one sentence.
Yes.
All right, what's the state's position on that?
It's the pattern instruction. It's clear to me. I don't see a reason to change with the instruction from the AOC.
Hmm. I wonder how they can change that though. How can you change something from being written in that law book?
Was kind of duplicitous because um, I'm telling them that she's determined by the same rule of credibility of other witnesses, and then this is the section on credibility of witnesses and
Well,
those
then,
other rules.
what we could do in the alternative would be in the credibility of a witness section, include a phrase that, the credibility of the witnesses, I'm sorry, the law presumes that every witness, including the defendant in this case, that would achieve the same goal. I just want to make clear that the law also presumes that Ms. Daniels is telling the truth, just as it does with all of the other witnesses.
What's the state's position on that?
Again, I don't know how that's not clear.
I don't either.
And specifically, just tells the jury that they're to judge her by the same credibility as every other witness. Adding anything just like almost emphasizes to the jury that you should believe the defendant more than any other witness in the state's mind. That's not appropriate. So the charge is clear, and it's the pattern charge, and I'm opposed to any change in that.
Your Honor, I disagree. I think that when we have referred to witnesses throughout this entire trial, and we have referred to the defendant throughout the entire trial, those sound like two separate parties. And so if the jury's not clear that even though she is the defendant, she also, under the law and under the instructions, is a witness that should be treated the same way as the other witnesses,
How?
then that's impairing her right to have a fair consideration.
I don't know about that. I don't know about that. You changing the law. You changing the law where the law is written. What is she saying? No, that won't be right.
But can we just say that the defendant is a witness and down
I think if you
testify defendant as a witness, having testified in her own behalf, her credibility is to be determined by the same rules that the credibility of other witnesses is determined, and you will have to give the defendant's testimony in this case such weight as you may think it is entitled.
Yeah, that's better.
Your Honor, I guess my issue with that is that the language in those two sections are very different. The language between the general credibility of a witness and the assessing defendant testimony is very different language. Give it whatever weight you think it deserves. It's very different than the law presumes that these people are telling the truth.
I'll come back to that one.
Yeah, you better look over that law.
There also, we talked a little bit a couple months ago about the Supreme Court denial of certiorari from Sotomayor regarding Tennessee's instructions on involuntary manslaughter. Justice Sotomayor took the position that Tennessee's instructions for sequential considerations in regards to second-degree murder and voluntary manslaughter are unconstitutional. And that is because voluntary manslaughter actually has an extra element that is not in second-degree murder. And we should be moving down and reducing elements rather than adding them. As far as the order of consideration being sequential, I would ask that the court instruct the jury to consider second-degree murder and voluntary manslaughter to be rather than sequentially, because voluntary manslaughter has that separate element that makes it different than second-degree murder. But it's an additional element, an additional finding that the jury would not be able to get to if they did not move past second degree. So I would just ask on the sequential consideration to ask to consider those two together.
Mm.
What's the state's position?
I don't, that opinion did not change the law in Tennessee.
She sure is trying to change the law.
Until the law changes, I think it's clear.
She's changing the law.
The way we charge this in Tennessee is first degree, second degree, and then all changes.
Right.
I mean, I get your point. I mean, it is, but you know, at this time, the law is what the law is. But I definitely get it. You know, it's an additional element.
Look, y'all, she can't change the law. What the defense attorney is trying to change the law to benefit her client. She can't. I don't see how they can do that.
The law, at this point, I have to follow what the law is.
That's right.
Currently. And so I note your objection because I get it's an additional element. And usually when it's a lesser included, it's one that goes, you know, it's a less element. But in this case, there is an additional element. And so it makes sense to me. But, you know, I have to follow what the law is.
That's right.
Which they go in their order. So I'm going to have to overrule at this time.
Thank you, Your Honor. And then I would just note on page 39, there was a somewhat duplicative,
Which one?
it was no outside communications, but on page 2, there's no independent research or discussions. So I just wanted to note the duplication.
Okay.
And it's not an exact duplication, but it's very, very similar.
Okay. Do you have any objection to that being removed?
No, ma'am.
All right.
Uh,
All right, give me a second on that other one. And just step off a little research.
Thank you, Your Honor.
All right.
But good try, defense attorney. Good try. But you can't change the law. You can't. Do a favor for me, Vita. Anybody come in the chat, greet everybody. Come in the chat. So, what y'all, she about to go in front of jury then. Now, see, if she go in front of jury, they're going to look at this case differently. Because they're going to look at this case differently. Because I can see where the pastor promised her some stuff. But they still, what she did, shouldn't have took. Her decision wasn't a good decision. Because he is a married man. He was one. All right, let me skip a little bit, see what else I got with him. I want to hear what she said about that first. I don't think she should change it.
The link is I feel
Hold on, y'all.
So tasty, it could make the
Sorry about
sun
that. Y'all
switch
see
to a
this?
smooth,
While
we
talking
divine
about
taste
editing,
from
when I
Greek
leave
gods.
here, I should be able to edit this video.
the link is I feel like it's duplicitous to put that in there twice because the defendant testified she's treated as a witness and the instructions say her credibility is determined by the same rules that the credibility of other witnesses is determined. And so the credibility of witnesses, there's a section titled that with everything that she's supposed to be given the same weight as everyone else. So I'm gonna deny that request at this time.
And Your Honor will not consider even adding the language that you had suggested about saying when she testifies, she's considered a witness.
I'm gonna leave it the same. All right, were there any other corrections? I gave each a copy.
She did.
Moments to look at it to make sure there's not anything else before we print them off.
If we could have it.
Okay, sure.
Good job, Judge. Good job, girl. Okay, I see what you did. We met there and read that book, didn't you? Okay. All right. Let's see. All right. Let me take it. Okay, here we go. I don't know why I feel for that lady. She look like a sweet little lady. But that I hate she made that decision. Cause like you said, Vita, she didn't have to.
Non-intentionality, the pattern instruction.
Which one?
Um,
Which section?
what was added to the criminal attempt?
That's a pattern instruction for criminal attempt. First, that's a pattern instruction.
Is it the pattern instruction for regular first degree?
It's two separate instructions. It's one for first degree murder, and then there's a separate instruction for criminal first degree murder with serious bodily injury.
Yes.
There's a separate instruction.
I guess my issue is that by adding, we're adding language to the criminal attempt first degree murder that's not in the pattern instruction. This says the essential elements to constitute first degree murder are, and then it goes into that paragraph that is not part of the pattern instruction.
I think that's what's
Once you change the language, you change that language, you're gonna have to change a whole lot of stuff. Got to watch her. But at least the defense trying. The judge not playing. I hate that happened to that girl.
This is first degree murder, but it's different than the pattern given for first degree murder.
it's an attempt. So it said the defendant unlawfully killed the alleged victim, that the defendant acted intentionally. Oh, we forgot in the killing was that's one. Make sure she had that.
So they trying to say she didn't intentionally. To me, is she intentionally,
That's the instruction.
not intentionally. Yeah, she intentionally.
Essential elements necessary to constitute first degree murder are the defendant unlawfully killed the alleged victim. That's under the first degree murder. In count one, the defendant acted intentionally. That's there, and then the killing was.
Yes.
Yeah.
What I'm looking at on the instructions that you're giving for first degree murder says that the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim.
Right. And so, what's the additional language is not there?
It just is, will be confusing to have two different definitions of first degree murder in the same.
The difference is that because it's criminal attempt first degree murder, there's a reference to Lling, statute Lling, and the fact that you can have the intent to
Kill another person.
And so
Right.
that's why the additional language is there in criminal attempt first degree murder versus first degree murder, because of the fact that you can get criminal attempt murder by just having the intent to kill someone, not necessarily the person who is allegedly indicted. So I think that's what the distinction is.
Okay.
It is.
I just was concerned by the fact that we have two different definitions of first degree murder.
I think it's just different
Okay. So she used the bracket language. I got to look that up. First degree murder and be night beater. I feel so sorry for her though. She just felt for him. She felt for him. And you got kids. Golly. Don't give a first degree. Give a second degree. I give a second degree because he played a little game with her, but she got to be strong. So I think it should be second degree because he played her. But I wonder what. Right. She had to be in love, but to go there for because she really didn't do that to her boyfriend to the first. She didn't fall for him. She was stressed. She was stressed out. That's the difference right here. She got stressed. And stress hit people differently. She looked, I hate that happened to her. She got them kids. God, hey.
Would Your Honor consider, given the issues about voluntary manslaughter and second degree murder, would you consider a sentence at the end of the first paragraph under second degree indicating with second degree the jury should should consider whether a heat of passion was present at the time of the alleged killing? Putting that they should be considering that at that point in time
Now
as
if
a way to address that issue?
it first,
This is a pattern instruction. So do you have any case?
Your Honor, you are allowed to change instructions. We're allowed to draft instructions and put them forward for the court's approval. They just have to comport with the law.
right.
And as long as they comport with the law, the court is allowed discretion within the jury instructions.
Okay. What is the jury asking for again?
So because of this issue, that is a very new issue brought up by that denial of writ, with Sotomayor basically telling Tennessee Supreme Court, you need to fix this. It's really unconstitutional. We have been told by the United States Supreme Court that our jury instruction framework is unconstitutional. This is a way to address that so that Ms. Daniels can
Be respectful of Vita.
court when they're comparing second degree murder and voluntary manslaughter. And especially when we're saying this is a voluntary manslaughter, that for them to not be allowed to move to that section because of the way that our jury instructions are ordered completely denies her right to a fair trial. So if we just added a sentence to say, this is the distinction between voluntary manslaughter and second degree murder, is that voluntary manslaughter requires the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Even if you just said, like the jury should consider whether a heat of passion was present during this alleged shooting. Here.
I think it's only the same thing though. Because, it's showing a distinction between both. And so.
Yes, but it's not telling them to consider voluntary manslaughter yet.
What's the state's position?
The law in Tennessee is that you charge first degree murder, second degree murder, and voluntary.
That's what I'm saying.
I think that's what the court should do.
And I get your point, Ms. Speaks. I do. I understand what you're saying. It's just, this is the law. And
She changing the law.
Follow what the law is. But I get your point.
And I'm not asking you to change the law.
Yes.
I'm asking you to provide some clarification to the jurors regarding the law. And that's what these instructions are supposed to do. They're supposed to help guide them through this process. And when we have a situation to where second-degree murder and voluntary manslaughter are sequential, they don't move to that heat of passion according to the jury instructions. They don't move to that heat of passion until they completely acquit of second-degree murder. Then if you don't tell them, you need to take this into consideration here before you, I mean, like if in the decision on whether or not to acquit on second degree and move down to voluntary manslaughter, then they don't get to the point that they are able to consider that as an element.
I don't know about that one,
That's
Judge.
asking them to do the cafeteria style that we're not allowed to do.
But what she doing is changing the law. She's changing it to benefit her.
Are the parent instructions adopted by Supreme Court and at this point I'm gonna deny the request. I get it, but I'm just gonna deny the request.
Right, Judge.
So what they have set out, you know, what would you use? So at this point I'm gonna deny the request.
Right.
Given the fact that the jury instruction requests specifically are supposed to be in writing, would the court give me a moment just to draft a pleading so that I can file it, to have it in writing to make the record? Yes, thank you.
She trying to change the law to benefit. She's doing what she's supposed to do. That's what she's supposed to do. Now the judge see what she doing. If I ain't no judge and I can see what she doing, you can hear what she doing. But she's doing a good job because that's what she's supposed to do. Cheat for her defendant. She doing right.
I know, Your Honor, I will include in that written request my additional request for the language regarding the defendant and witness credibility.
But other than that, there's no those objections. Was there anything else?
The issue, did you take out the language of the?
She's still trying to take out the language.
I took that out.
She told you.
Correction.
I said her name yesterday, girl. I can't remember these people's name. I think her last name, I can't think of her. I do so many cases. I don't remember.
When you
I
feel
can't remember her
overwhelmed,
her name.
there's a
I
better way
had
to
it said I deal with so many different cases. But I know the pastor name was Perry. And her last name was something. I can't remember. That ain't nothing for me to remember. That's what we said. God, I can't remember what I said her name was. Just say defendants. I don't have to worry about that. You can go back and look at one of my videos that I did yesterday. Her name, I mentioned her name. Feel sorry for her though. If she hadn't had me as a friend, she wouldn't have did that. Her name was Latoya. I think her name Latoya something. Latoya, I think. But I don't know. Y'all try not to ask me these people's names stuff because I deal with so many cases. But I think her name Latoya. Latoya something. I can't think of her last name. And I think the pastor's last name was Perry, if I can remember. I'm sorry for her. And she's so sitting there so pleasant. She just sitting there so sweet. God.
Before the section on defendant testifying.
What's his last position?
sure what the purpose of it is if the defendant testified.
What's the point?
Your Honor, it's to clarify the burden of proof. It is to make clear, and I'm checking the burden of proof section now.
Yeah, so young. I wonder why she can't testify.
Being clear that that does not place a burden of proof on the defendant.
She can testify if she want to. What is he talking about? But then I would her. I wouldn't testify. I wouldn't say nothing. I let the jury figure it out.
The state has the burden of proof of the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains the state throughout the trial of the case. The defendant is not required to prove her innocence. So I
Oh.
think this shouldn't have to prove anything.
No, she don't have to prove nothing. I wouldn't say nothing. I wouldn't say anything. She don't need to say nothing because what she said yesterday, she was guilty. Let the jury figure it out. Come on, attorney. She don't need to get on the stand. I agree with you too. I agree with you. You can always speak your opinion. That ain't. We've got to see what the jury gonna think. I agree with you. She didn't have to. You're right. She definitely didn't have to. You're real talk. That's the truth. Latasha. Okay. Daniel. Okay, that's it. See, I can't remember their names, but I know it was Latoya, little something. So it was Latasha. I say Latoya, but okay, you found out what you. All right. Oh, that estimate. Daniel. That's what I couldn't. I couldn't think of Daniel for nothing in the world. But I agree with you too. Real talk. I think she's going. I think that she's just going through something mentally. I'm not gonna. She needed some help, and she didn't get the help that she wanted. But if she got to sit in front of a jury, I wouldn't put her on stand. She don't need to testify. Let them figure everything out. Let the jury figure out what the how the prosecutor can prove whether she guilty. Now we can say anything, but you don't know how the jury gonna turn out. Same like this is the same courtroom, but a different judge and different prosecutor and different defense attorney that Hernandez had. I knew he was gonna be guilty. He wasn't gonna be guilty before they said he was guilty. I already listened to the witness. So the witness that they're gonna put on the stand is what's gonna determine is she guilty or not guilty. Not what we think. I can listen to I never heard the witness talk. I never seen the witness. So the witness, that prosecutor have to prove that, got to prove that point. Regardless of what we think and feel. Cause in her case, I don't give her no excuse for reacting the way she did, but I can see some problems on his behalf too. But she, woman, she didn't have to do that, but she chose to do it. But now they're gonna have to find out, did he give her that reason to do that? I'm telling y'all how it's gonna be in the court. So we got to hear what the witness going to say. That lady was fatal attraction. Minnie talking in her sleep, y'all. Excuse her. Okay, let me put it right here.
The defendant
Pleads not guilty.
Hold on, because I got to hear what this defense attorney saying. Hold on.
Happy hour at Chewy's. I needed this. Me
Ooh, that look good.
The defendant pleads
Hold on. Let me hear what she's saying. She got a good attorney. Let me skip it a little bit. Trying to push it up a little bit.
The defendant pleads not guilty to the offenses as charged.
what's the state's position on that?
Either one of those.
The defendant
Pleads not guilty to the offenses as charged in the indictment.
I couldn't put it on that part she was talking
pleads
about.
not guilty to the charge. This is what is charged.
To the offenses as charged in the indictment.
Charge in indictment, okay.
And just semantically, I'd probably rather offenses charged rather than crime charged.
Offense is charged.
Yes.
What's the state's position?
Yeah, I give it an answer. It's a crime. It's charged as a crime. And that's what this charge says. So I don't know why we would change that.
Offense is charged crime. Same thing. Offense is charged. So do you want to keep the language about the plea?
If we could just add that final sentence, the defendant pleads not guilty to the offenses as charged in the indictment.
Okay, but the heading.
Yes, then we can leave it offenses charged and plea. And then it outlines the offenses and then gives the plea.
Okay. All right, so were there any other changes besides that? Before we make the copies? I noted your objection.
Thank you, Your Honor. I do have that written request on the way.
Okay.
They handle business. Now people who watching, don't be surprised if she don't turn out being not guilty. Because you're going to have a jury. I can see where she's not guilty for something. I can see where she's guilty of something. I can see both, and I don't know how they're going to do that. So that's why I don't play with nobody's feeling. If I don't want to be with them, I'm not going to be with them. I'm not going to promise them nothing or nothing. If I don't want to be with them, I'm not going to be with them. I ain't going to play with their feelings. And a lot of people get hurt by people playing with their feeling. So y'all got to think about the jury, the people of the jury. Somebody don't been in that situation before, cause they got to pick them people who they want to pick. And so somebody could have been in a situation like hers before. And regardless of, how we see it, I can see guilty and not guilty. I see, I got that. She don't need to talk. She don't need to testify no more. She don't need to say nothing else. Because what she said when I heard her, uh, she was in a mental state of being. From what I heard from the first time, when we listened to it yesterday. So when a person in a mental state of being, they'll do anything. So what caused her to be in that mental state of being? Think about it, y'all. I ain't on her side. On her side, I'm just thinking it like that. She got a good attorney. Yeah, her attorney is speaking out for her because her attorney knew. I don't know why that attorney mentioned her taking that stand. And like the prosecutor said, I'm used to her taking the stand. If she take the stand, they're gonna find her guilty. So keep her off the stand. Because she told y'all the truth. I'm just saying in the court why, I ain't on her side for doing that. But I'm just saying. So kind of like remind me of Hernandez. I told them that Hernandez was going to turn out being not guilty due to the fact of the witness. See, y'all got to, when they put that witness on the stand, I knew he wasn't guilty from what the witness said. And really, they didn't have enough proof or evidence to say what Hernandez did. They was going by hearsay from somebody who already locked up. So in her case, we don't know what the witnesses is going to say from the prosecution side. See, if somebody get on that stand and say they seen them together and da 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 and dee 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 dee, regardless, I know y'all saying Lanita don't know what she talking about, but Lanita gonna be knowing what she talking about. All depends on who the witness is that get on that stand, and the jury has to listen to them. Not me, but the jury. This is one of the cases where they should actually plead temporarily insane. That's what I'm saying. See, Vita, regardless of way, this thing could turn either way. It can be turned around. That's what the prosecutor was doing, but she didn't say it right. Not the prosecutor, but the defense attorney. I know I'm not saying what they want to hear. I know they want the lady to go to jail and do that, da 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 da. But, hey, to the point that we got to think about what the jury going to think.
Yeah, I thought of when you walked out was adding page numbers. Oh.
What's your position, Mr.
I don't have a position on page.
Okay.
We don't, if you've already started printing.
We haven't printed yet. Okay.
She was still trying to send us to the end. But those people who disagree with what I'm saying, when you got a jury and no witnesses get on that stand and they said something about she was in every time you seen her, she was with him and he did that and that. It sounds like a relationship. It's gonna be insanity. I'm telling y'all. And I don't care, I'm just telling them that's which way it can go. And on the pastor behalf, he shouldn't have been playing with her mind mentally, because he's supposed to be a counselor. So y'all got to really look at this. I'm telling you. This is good, huh? I'm glad I caught this. But they need some men. They may need some men. I wonder how I gonna end up with more men. I wonder if it's gonna be more men on the jury than women, either teachers or pastors, first ladies. I wonder how they gonna pick that jury. Yeah, Lord. It's gonna be interesting, y'all. When this court start, it's gonna be interesting. What's she saying? I like that judge. What the judge told her, I can't change the rule. Now, I hope during the court that defendant don't mess her up.
Just kind of as a logistics matter, are we planning to charge lunch close? It's 11:15 now. And it's looking like it's gonna be that way, but I was hoping that we could get it done before lunch, but it's probably not going to happen. I was hoping.
The court's been limited video time.
I was a
See,
huge fan of Rihanna when I was in high
she
school and college.
taking
So
that
fan.
judge kindness for witness. Judge need to stop smiling so much and get serious. So they going to lunch? What did you say to the point that the surveillance is camera show? We ain't seen no camera. We ain't seen nothing. I didn't. I ain't seen nothing. When we watched it yesterday, I didn't see no cameras. Oh, they went to lunch. Okay, wait, let me move it.
We're gonna go ahead to the trial that we've been covering all week for Latasha Daniels.
The surveillance. Now, we don't know what the has. She just looks so like she in peace. Like she not here. Wow. What's going through her mind? I wonder if she can change something. What would she do different? See, to the point, you need to ask some of your questions that you have in your class. That's what you say you was in class. So you need to ask some of the questions during these little trials and stuff that we can help answer. And then you could tell them that I finished college. I know all this stuff we had. Because everything you learn, you're going to have to turn it into a paper. I don't know what's going on in her mind. Nobody know what she thinking. Go to jury, y'all.
Are we ready to get back to work? It's now time for me to instruct you on the law. You can pass it on to the instructions.
Leader, speak to Theresa.
State of Tennessee versus Latasha Daniels, indictment number 2501253. Members of the evidence in this case has been completed and the arguments are soon to follow. Now it is my duty now to instruct you as to the law. The law to this case is stated in these instructions. It is your duty to carefully consider all of them. The order in which they are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts and decide in this case. You should consider all of the evidence in the light of your own observations and experience in life. Offenses charged and plea. The defendant, Latasha Daniels, is charged in count 1 of the indictment with the crime of murder first degree. The offense necessarily includes the lesser offenses of murder second degree, voluntary manslaughter, reckless homicide, and criminally negligent homicide. The defendant, Latasha Daniels, is charged in count 2 of the indictment with the crime of criminal attempt murder first degree. The offense necessarily includes the lesser offenses of criminal attempt murder second degree, criminal attempt voluntary manslaughter, and reckless endangerment. The defendant, Latasha Daniels, is charged in count 3 of the indictment with the crime of employing a firearm during a felony. The offense necessarily includes the lesser offense of possessing a firearm during a felony. The defendant pleads not guilty to the offenses as charged in the indictment. The law makes it the duty of the court to give and charge the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them on the trial and under the law given them by the court, render their verdict with absolute impartiality. No independent research or discussion. You as jurors must decide this case based solely on the evidence presented here within the four walls of this courtroom. This means that during the trial, you must not conduct any independent research about this case, the matters in the case, and the individuals involved in the case. In other words, you should not consult dictionaries or reference materials, search the internet websites, blogs, or use any other electronic tools to obtain information about this case or to help you decide the case. Please do not try to find out information from any source outside the confines of this courtroom. Until you retire to deliberate, you may not discuss this case with anyone, even your fellow jurors.
So tasty, it could make Poseidon switch to a spoon. Holy divine taste from the Greek gods.
The new razor slaps.
After you return to deliberate, you may begin discussing the case with your fellow jurors, but you cannot discuss the case with anyone else until you have returned a verdict and the case is at an end. I hope that for all of you this case is interesting and noteworthy. I know that many of you use cell phones, the internet, and other tools of technology. You also must not talk to anyone about this case or use these tools to communicate electronically with anyone about the case. This includes your family and friends. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, or the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including but not limited to Facebook, LinkedIn, YouTube, Snapchat, Instagram, Google, Twitter, or any social media to communicate to anyone any information about this case or to conduct any research about this case until you have returned your verdict and the trial has concluded. No sympathy or prejudice by the jury. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any.
Excuse me, y'all. Let me put this pillow up on it. No, Teresa, you never did jury duty? Can't even talk to us. She can't. They can't even watch us.
Once upon your verdict, you must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. Notes. Members of the jury, you have been allowed to take notes in this case. The court charged you that these notes are for your individual use only, and you should not use said notes directly or indirectly to the jurors as to the accuracy of said notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by the maker of said notes as an aid to his or her individual memory. Indictment. The indictment in this case is a formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements and arguments of counsel. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. The court will now explain to you the law applicable to count 1 of this indictment, murder first degree. First degree premeditated killing. Any person who commits the offense of first degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant unlawfully killed the alleged victim, Brodus Spirit. And 2. That the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. And 3. That the killing was premeditated. Intentionally means that a person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the crime after the passion has subsided. Second-degree murder, knowing killing of another. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant unlawfully killed the alleged victim, Brodus Spirit. And 2. That the defendant acted knowingly. Knowingly means that a person acts with an awareness that her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant subjective or desire to cause the death of the alleged victim. A defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended the death of a person, then the killing of another, even if not the intended victim, would be second-degree murder. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant unlawfully killed the alleged victim, Brodus Perry, and 2. That the defendant acted intentionally or knowingly, and 3. That the killing resulted from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions which renders the mind incapable of cool reflection. Intentionally and knowingly have previously been defined in these instructions. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant killed the alleged victim, Brodus Perry, and 2. That the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and a degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Intentionally and knowingly have previously been defined in these instructions. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant's conduct resulted in the death of the alleged.
When you feel not,
So
there's
hard.
a better way to calm. With Cold Calm.
The holidays are just around the
There's
corner.
so many
And at Eddie
commercials
Bauer, we're
I
here
have to
for
delete.
every adventurer
Edit.
on your list. Whether racing
Of the alleged victim, Brodus Perry, and 2. That the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk is such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. Intentionally, knowingly, and recklessly have previously been defined in these instructions. If you find beyond a reasonable doubt that the defendant was criminally negligent, you must also find that the death of the alleged victim was the proximate result of the defendant's criminal negligence. The defendant's action need not be the sole or immediate cause of death. If you find that the direct cause of death was an act of the victim, before you can convict the defendant, you must also find beyond a reasonable doubt that the act of the victim causing death was a natural and probable result of the defendant's criminal negligence. The court will now explain to you the law applicable to count 2, criminal attempt first-degree murder charge in this indictment. Criminal attempt first-degree murder. Any person who attempts to commit first-degree murder where the victim suffers serious bodily injury is guilty of a crime. For you to find a person guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1. that the defendant intended to commit the offense of first-degree murder against alleged victim Tabitha Perry, and 2B, that the defendant did some act intended to cause an essential element of first-degree murder to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part, and 3, that the alleged victim Tabitha Perry suffered serious bodily injury. New and known means that a person acts knowingly with respect to the conduct or to circumstance surrounding the conduct, and the person is aware of the nature of the conduct or that the circumstance exists. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Intent means that a person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. The essential elements necessary to constitute first-degree murder are 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. A defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause the result, the death of a person, and that she did so with premeditation, then the killing of another, even if not the intended victim, would be first-degree murder. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered in order to determine whether the accused is sufficiently in passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss of substantial impairment of bodily function of a member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Criminal attempt, second-degree murder. Any person who attempts to commit a criminal offense is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of second-degree murder, and 2B, that the defendant did some act intended to cause an essential element of second-degree murder to occur. At the time, believed the act would cause the element to occur without further action on the defendant's part. Intent has previously been defined in these instructions. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The essential elements necessary to constitute second-degree murder have previously.
Protect your home. $39 whole home plumbing inspection from Ragsdale.
When I wake up in the morning light.
Have previously been defined in these instructions. Criminal attempt, voluntary manslaughter. Any person who attempts to commit a criminal offense is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of voluntary manslaughter, and 2B, that the defendant did some act intended to cause an essential element of voluntary manslaughter to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable to act in an irrational manner. Intent have previously been defined in these instructions. The essential elements necessary to constitute voluntary manslaughter have previously been defined in these instructions. Reckless endangerment. Any person who commits the offense of reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. One, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury. And two, that the defendant acted recklessly. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond a reasonable doubt that a person or class of persons was in a zone of danger. The zone of danger is that area in which reasonable probability exists that the defendant's conduct would place others in imminent danger of death or serious bodily injury. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss, or substantial impairment of the function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Recklessly, intentionally, and knowingly have previously been defined in these instructions. The court will now explain to you the law applicable to count 3, employing a firearm during a felony charged in this indictment. Employing a firearm during the commission of a dangerous offense. Any person who employs a firearm during the commission of a dangerous offense is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant employed a firearm, and two, that the employment was during the commission of or murder against alleged victim Tabitha Perry, and that the defendant acted intentionally, knowingly, or recklessly. Employ means make use of. Firearm means any weapon designed, made, or adapted to expel a projectile by the action of an explosive or any device readily convertible to their use. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it's a person's conscious objective or desire to engage in the conduct or cause a result. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstance surrounding the conduct when the person is aware of the nature of the conduct or that the circumstance exists. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause a result. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and justifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. The court instructs you that as to count 3, the term dangerous felony is limited to criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter. Furthermore, the court instructs you that a defendant may not be found guilty of this offense unless you find she is also guilty of criminal attempt first-degree murder, criminal attempt second-degree murder, or criminal attempt voluntary manslaughter against the victim Tabitha Perry. The essential elements of criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter are these instructions. Unlawful possession of a firearm with intent to go armed during the commission of or attempt to commit a dangerous offense. Any person who possesses a firearm during the commission of a dangerous offense is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant possessed a firearm, and 2, that the possession was with the intent intent to go armed during the commission of or attempt to commit criminal attempt first-degree murder. And 3, that the defendant acted intentionally, knowingly, or recklessly. Intentionally, knowingly, recklessly, intent, and firearm have previously been defined in these instructions. Possession may be actual or constructive. A person who knowingly had direct physical control over an object at a given time is then in actual possession of it. A person who, although not in actual possession, knowingly had both the power and intention at any given time to exercise dominion and control over an object is then in constructive possession of it. Possession may also be sole or joint. If a person has actual or constructive possession of the thing, possession is sole. If persons have actual or constructive possession of a thing, then possession is joint. The court instructs you that as to count 3, the term dangerous felony is limited to criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter. Furthermore, the court instructs you that the defendant may not be found guilty of this offense unless you find she is also guilty of criminal attempt first-degree murder, criminal attempt second-degree murder, or criminal attempt voluntary manslaughter against the victim, Tabitha Perry. The essential elements of criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter have previously been defined in these instructions. Presumption of innocence. You enter upon this investigation with the presumption that the defendant is not guilty of any crime, and that this presumption stands as a witness for her until it is rebutted and overturned by competent and credible proof. It is therefore incumbent upon the state, before you can convict a defendant, to establish to your satisfaction beyond a reasonable doubt that the crime charged in the indictment has been committed, that the same was committed within the county of Shelby in the state of Tennessee before the filing of this indictment, and that the defendant at the bar committed the crime in such manner that would make her guilty under the law heretofore defined and explained to you. The law presumes that the defendant is innocent of the charge against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof, general.
Bergamot County Fest is the place.
Proof, general. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. Burden of proof, elements and date of offense. The state must have proven beyond a reasonable doubt all the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Impeachment of witness. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with the witness's evidence on the stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not the truth of the matter asserted in such out-of-court statements. Excuse me. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improper statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it plainly appears that some witness has testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony about the facts of certain credibility of witnesses. You should consider all the evidence presented in this case by the state and by the defendant and give it a full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are, based on what you heard from the witnesses. If there are conflicts in the testimony different witnesses, it is your duty to reconcile them if you can. For the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything that witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors. 1. How the witness looked, acted, and whether the witness appears to be telling the truth when he or she testified. 2. Whether the witness was in a position to know about the matter to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard. 3. Whether the witness's statements were consistent and how believable the statements were. 4. Whether the witness had a motive to testify truthfully or to testify untruthfully. And 5. Any proof presented of the witness's reputation for telling the truth. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it plainly appears that the witness has willfully testified falsely. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness, means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters. If any are shown and all the evidence in the case tending to corroborate or contradict him or her. Expert witness. During the trial, you heard the expert
Let me see, can I skip some?
testimony of
Jesus. Oh, she was almost finished.
identification. The court charged you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the alleged crime with which she is charged. In considering the identity of a person, the jury may take into consideration all the facts and circumstances in the case. The court further charged you that you are satisfied from the whole proof in the case beyond a reasonable doubt that the defendant, Latasha Daniels, committed the crime charged against her, and you are satisfied beyond a reasonable doubt that she has been identified as the person who committed the crime charged, then it would be your duty to convict her. On the other hand, if you are not satisfied with the identity from the proof, or you have a reasonable doubt as to whether she has been identified from the whole body of the proof in the case, then you should return a verdict of not guilty. Evidence, direct and circumstantial. One type of evidence is called direct evidence, and the other type.
So there I was.
God, I tried to skip in the commercial.
Still in the box. It's like things.
And the other type is called circumstantial evidence. Direct. Deliberation, order, consideration.
I skipped it, y'all.
In reaching your verdict, you should first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty. And you guilty of first-degree murder as charged in count 1 in indictment 2501253. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt of this offense, you will next consider her guilt of a lesser included offense in order of their consideration from greatest to least as set out on the previous page. If you unanimously find their verdict should be, we the jury find the defendant guilty of employment of firearms during a felony is charged in count 3 in indictment number 2501253. If you find the defendant guilty of this charge, you must identify the felony, either criminal attempt, first-degree murder, checkbox, criminal attempt second-degree murder, criminal attempt voluntary manslaughter checkbox. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt of this offense, you will next consider her guilt of the lesser included offenses in order of their consideration from greatest to least as set out on the previous page. If you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, your verdict should be we the jury find the defendant guilty of blank as included in indictment number 250153. Insert and said blank the lesser included offense. If you find the defendant guilty of the lesser included offense, you must identify the felony.
They got to have a paper.
First degree murder, criminal attempt, second
They
degree
got to
murder,
have
criminal
instruction.
attempt, voluntary manslaughter. If you have a reasonable doubt of the defendant's guilt of the offenses charged and included in count 3, it's your duty to acquit her, and your verdict should be we the jury find the defendant not guilty in count 2 of indictment number 2501253. You will write your verdict on the verdict form attached and sign one of your names to the verdict as foreperson. Selecting foreperson. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom, and your foreperson will announce the appropriate verdict form to the court. Take the case, consider all the facts and circumstances fairly and impartially, and report to the court such verdict as truth dictates and justice demands. Signed, Judge Jennifer Fitzgerald, Criminal Court, Division 2. All right, so I have given you the law in this case. We're going to recess for lunch. When we come back, you hear the attorney's closing arguments. And I have to remind you again, we're still not ready to discuss the case, okay? So I'm gonna excuse you for lunch. We'll come back, I guess at 1:45. I'm not sure if lunch is there. We'll come back at 1:45. But I'm gonna excuse you for lunch, and we're still not ready to discuss the case.
Okay, they're going to lunch. Now how I'm gonna get to the I wonder how I'm gonna get to the lunch thing. I could skip it, but I ain't got no more room. Let's see how I gonna do. Let me see when it go off. Then it'll start over. But y'all, this lady, she's lunch. Yeah.
Come back at 1:45.
Yeah, miss. From at lunch. It's Friday. I don't guess they gonna come on. I don't know how they did that. I don't know how did they do it because it went to something else. So let me see. They hold up, here it go right here. The closing argument. Okay, y'all, here it go. It's the closing argument, y'all.
I felt used. He broke up with me in a disappearing text message. Who does that to someone that they love? I wanted him to feel the pain that I felt. These are the words of the defendant, Latasha Daniels. And earlier this week, we told you that you would hear a lot of testimony. You would see some pictures, you would see some videos, but most importantly, we wanted you to pay attention. And a key part of paying attention is not getting distracted, not getting confused as to who finish here today, you'll see that this case really isn't that complicated. It's kind of easy. She's charged with 3 counts: first-degree murder, criminal attempt first-degree murder, and employing a firearm during the commission of a dangerous felony. First-degree murder, and you'll see this in your jury instructions, is defined as a premeditated killing of another. 1, the state has to prove that the defendant unlawfully killed a victim. 2, the defendant must have acted intentionally. 3, the killing must be premeditated. So, what is considered unlawful? Well, what is considered unlawful killing? One example can be the defense of others or yourself. Intentional. What does it mean to be intentional? Does it seem like an accident? Does it seem like a mistake? Your jury instructions say that something is intentional if it's a person's conscious objective or desire to cause the death of another person. Number 3, premeditation. The killing has to be premeditated. And as we learned in voir dire, premeditation doesn't have to be a specific length of time. It could be 2 seconds, 2 days, 2 weeks, 2 months. There's no time frame. It just means that you had to think about your actions and you had time to reflect. It could be as simple as stepping out of your car, raising your arm, and the time it takes you to point the firearm at someone and shoot and kill them. Or in this case, it could be driving to the gun store, purchasing a gun, purchasing ammunition, leaving the gun store, driving 3 hours to Memphis to your married ex-boyfriend's house, and knocking on their door. So this week, we started off hearing from Tabitha Perry. She testified that her husband was an executive pastor in Little Rock, and later he moved to Memphis along with her for a new position at Mississippi Boulevard, a prominent church here in Memphis. She also testified that they knew the defendant. They knew her from Little Rock when he was previously working over there. And on April 4th, 2019, Mrs. Perry heard a knock at her door. When she went to her door, the defendant was standing there. Now, she thought it was odd that Miss Daniels was standing there, but she didn't think too much of it because they had given their address out to several people at the church in Little Rock. After she let her in, Mrs. Perry and the defendant sat and talked about 20 minutes until Brotus Perry showed up. When Mr. Perry showed up, the defendant even told you that they sat and talked for a while. She even took a drink. And once she decided that it was time to go, Mrs. Perry and Mr. Perry led her out of their doorway. And as Mrs. Perry was leading her out of the doorway, she turned back and she saw the defendant reach into her coat pocket, remove a gun, and shoot Mr. Perry in his own doorway. Once she did that, Mrs. Perry looked to her neighbors for help. She tried to get help, and then when she saw her husband lying on the ground, she went to go help him. She pleaded with the defendant, "Why are you doing this? Why is this happening? Please stop." Well, not only did the defendant not stop, she shot Mrs. Perry. And not only did she shoot Mrs. Perry, she reloaded her gun.
What?
After Mrs. Perry, we heard from Detective Roberts. He testified that the very weapon that was used to shoot Mr. and Mrs. Perry was purchased hours prior to this incident. He testified that the defendant purchased that firearm at a gun store at around 4:30 that same day in Sherman, Arkansas. Detective Roberts told us that he spoke to Ray Palladino, the general manager of that sporting goods store. From Mr. Palladino, he received the surveillance footage. And that Surveillance footage showed the defendant coming in, purchasing a gun, purchasing ammunition, and leaving. Mr. Palladino also provided Detective
Okay,
Roberts with a receipt. That receipt had the defendant's first and last name on it, had the serial number of the Ruger handgun that she purchased, and the last 4 digits of her credit card. It's the same credit card that the detectives discovered in the defendant's vehicle when he searched it. We also heard from Dr. Curry. Now, Dr. Curry testified that she performed Mr. Perry's autopsy. She testified that the cause of death was multiple gunshot wounds, and the manner of death was homicide. She testified to recovering the bullets, placing them in an envelope, initialing and dating them, and leaving them to be picked up. But Dr. Curry isn't the only doctor we heard from. Defense put on Dr. Bidding. Dr. Bidding was hired by the defendant and her team. And you heard her. She testified that she has testified for more defendants than she has prosecution. And ladies and gentlemen, think carefully about what she told you. She told you that depression and someone does not mean that they cannot form the intent to kill someone. She also told you that she didn't even offer an opinion as to the defendant's mental state at the time of the offense. So what do we need? We need an unlawful killing, intent, unlawful killing. Well, there was no self-defense claim, and the only other firearm found in the residence, found in the crime scene, was in a box under a nightstand in a completely separate room. Intent. I wanted him to feel the pain that I felt. He broke my heart. You heard that from the defendant herself. Premeditation. We'll take your pick. Whether it's the drive to the gun store, the time it took to purchase, choose a firearm and ammunition, the time it took to drive 3 hours to Memphis to her ex-boyfriend's house, or the 20-minute conversation she had when she finally went up to their apartment. Criminal attempt first-degree murder. So in your jury instructions, you'll see what's on the screen right here. That's a lot of words. But the judge is giving you the law, and the best way that I can describe it is that the defendant must have an intent to commit first-degree murder. But they fell short for some reason. The act wasn't complete. And that's how you have criminal attempt first-degree murder. We heard from Tabitha Perry, and she testified that she was shot in the shoulder. After the incident, she was transported to the hospital, and the doctors left the bullet inside of her. It wasn't until later that she had to get it surgically removed. It was causing her extreme pain, and by the time that she got it removed, it was poking out of her back. And even today, 6 years later, she is still suffering from pain from that incident. Now let's talk about transferring intent. You heard in your jury instructions that sometimes when you intend to kill one person and you don't kill that person, but you kill another person, that is how the transfer intent happens. Tabitha Perry testified that when she spoke to police, she told them that she didn't even believe that the defendant meant to hurt her. But that's okay. Because you don't have to actually hit your intended target to be charged and convicted of criminal attempt first-degree murder. As long as you have the intent to kill one person, it doesn't matter that you accidentally shot or you actually shot someone else. Your intent is still there. The only thing that's different is the person that got hurt. Employing a firearm during a dangerous felony. So on the screen here, it says that any person who employs a firearm during the commission of a dangerous felony is guilty of a crime.
Give me that.
That the defendant employed a firearm. 2, the employment was during the commission of attempt to commit criminal intent first-degree murder against the alleged victim, Tabitha Perry. And 3, that the defendant acted intentionally, knowing, or recklessly. In addition to Mrs. Perry's testimony, we heard from Captain Draper, Officer McLean, and Special Agent Brosset. Draper testified that he and McLean were a few of the officers that responded to the crime scene on the offense day. And when he got there, he witnessed the defendant holding a firearm. She refused to comply with orders. Captain Draper testified to the non-lethal force that was used to unarm her. Officer McLean testified to securing and clearing the weapon that the defendant had in her possession. He noticed that there was nothing in the chamber, but yet there was a magazine in the gun. Special Agent Sane testified to the ballistics. He examined the Ruger, the casings, and the bullets from the medical examiner. He determined that all the cartridge cases and the bullets had been fired from that same handgun that was recovered off of the defendant. And now we're back at the beginning. You broke my heart. So I'm going to purchase a firearm. You broke my heart. So I'm going to purchase ammunition. You broke my heart. So I'm going to take that gun and the ammunition and drive 3 hours away to your home. You broke my heart. So I'm going to knock on your door. You broke my heart. I'm going to sit there and talk with you and your wife for about 20 minutes. You broke my heart. So I decide to leave. You broke my heart. So I'm going to shoot you and kill you in your doorway. And along the way, shoot your wife. But it's okay, because you broke my heart. Decision after decision after decision. Ladies and gentlemen, if a broken heart was an excuse or a defense to murder, I wouldn't have a job. The standard of proof in this case is beyond a reasonable doubt. Not 100% certainty, not beyond all doubt, not beyond a shadow of a doubt. What's required is certainty that lets you rest easy at night. And now it's your turn. After you consider all of the evidence and apply the law that the judge has given you and use your common sense, the state is confident that your verdict will be guilty as charged. Don't let a broken heart distract you from the human life that was lost. Thank you.
I want to go back and look at what the wife said. I want to listen to her testimony because I didn't see her testimony. I want to go back and hear what his wife said. Cause the prosecutor said that the wife said she don't think that she was intended to hurt her. So she think that was her mental state of being. So the wife may know her husband better than anybody. This is kind of tough. That's what I want to say. I want to hear what the wife got to say. I wonder what happened because it's the time. Turn. No, they talk to me though. Let me see. Okay. Defense time, y'all.
Yes, ma'am. Good afternoon. We have told you from the very beginning that Ms. Daniels is not denying what happened. She is not saying, I have no responsibility. I have no accountability. That is not our position, and it has not been our position from the first time that we talked in Wood Attic. We told you she is guilty of something, but she is not guilty of first-degree murder and criminal attempt first-degree murder and employing a firearm in felony. That is not what these facts illustrate, unless you're looking at them from far, far away and ignore all of the details and all of the influence. When I was in high school, one of the you see, I saw Abraham Lincoln. See a different side, and sometimes even then, you miss it. He was a manipulative person. I know that he is not here anymore, and that is a tragedy. But that doesn't change the fact that during his time on Earth, he manipulated the women in his life. He was controlling, and he wanted this lifestyle of ethical non-monogamy. Regarding the ethical non-monogamy, that was, when I talk about the manipulation of women in his life, that was a big source of it. He manipulated Tabitha into thinking, oh, well, this is just something that I thought about. It's okay that you don't want to do it. He manipulated Chriselle and Danielle, who he had the Marco Polo group with, in that he made this whole fiction where his wife was completely on board with this, and he was living this open, honest, and transparent lifestyle where he was ethically engaging in non-monogamy. As a pastor of the church looking for a group of people who would sanction his behavior, he found women and lied to them about this. He manipulated Latasha in so many ways. But regarding the ethical non-monogamy, his position was, my wife says it's okay, so my girlfriend should not be saying no. Even to Latasha, he lied about Tabitha being opposed to this lifestyle. When Latasha got involved, she thought Tabitha was on board with this ethical non-monogamy, and she was not. We heard from Brodus Perry manipulating these women.
Those are an issue at home, but I get it, but it ain't an issue. I have been though, so if we're talking, let's switch subject and get a little more serious. You know, for me, our agreements have been simple, right? No exes. Nobody from Jacksonville, Florida, which is home for us, and nobody in the 60 that you live in, which means nobody in Memphis. That was the case, of course, in Little Rock outside of Girlfriend, because Girlfriend is in Little Rock. The way that it kind of happened is, short version, when she decided to open up the marriage and allow go to her for therapy, but she asked her some questions. And based on this therapy session she had with this other lady. And she was asking her some questions after she had just said, bro, this is what I'm gonna let you do, blah, 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 it is what it is. Go from there. She asked her some questions. And so she was like, I just got a couple questions for you. And, they were gonna play tennis together. She was one of the leaders. And so we had rapport. Like, we had rapport. And she asked a question. And it was like, yeah, Maze, I'm thinking about this. And what do you think about this? Or what do you think X, Y, Z could potentially become? And I'm sorry, I'm looking to see who's in the Star Lounge because this is not where I really frequent therapy. So I'm kind of careful about what potentially is in here because I don't want to glass on past them. I really want to go in and go shield and look back. But I remember. But yeah, I'm trying to think of what's going on now. But anyway, so the next thing that she shared with her was, my husband like you, right? What he thinks you're attractive. And she was like, what? He's like, yeah, I know what he likes. And he thinks you're attractive. Not that he's been rude or anything like that. We've had conversations. Well, we did. Because like one time we was sitting around having lunch. And she asked me, I was like, well, you gotta get it. I ain't gonna get it. I'm coming across with this creepy guy, right? We're trying to spice things up. In that regard, that was even somewhat limited with the idea of somebody watching me, which that's neither here nor there. But when the question came up, it was her, right there. She asked, well, who would you want? And that was the first thing I said. She said, I know you like her. I know. So anyway, so she said, like you, blah, blah, blah. And she said, if you were interested, I'm not saying that you are, but I'm giving him this X, Y, and Z, and he may come your way. And she did. But she said, okay, cool. So we had a conversation. And after that, that's when the whole nobody in the city thing came up. It was more like, how do you feel bad for her? Because I essentially gave you that. But nobody. So I'm trying to figure this. So fast forward is a whole other shit, like trying to get the right plan. So I've been thinking about the past couple weeks in terms of expanding, my ethical non-monogamy and just kind of, so my wife, her and I were chatting up there, like, baby, I got a couple questions, I'm just curious, she knows about the term, and so I was like, when do you want to know? When do you want to know someone who has my interest or someone who I would like to pursue? Do you want to know the moment that I feel like it's more than just banter? Do you want to know at the moment that I would like to begin to banter? Do you want to know once I feel like it might be a thing beyond banter? Or what? Because this is kind of new for us, right? Because, girlfriend, Tasha, that's easy. That's been 2 years. That's been it for the most part. Outside of me going, that's out my birthday. But it's kind of been easy in that regard. So we're trying to figure out what does that look like. So I'm just kind of really thinking through where I am with that, right? Where I in terms of the look. So there's a lot of newness. And I said that just to say that there's some. There's still a lot of newness even in this ethical non-monogamy that I'm wrestling with. And it's fun, right? It's fun. It's interesting. It's causing us to communicate and chat and really talk again about different things that we've kind of, in a real sense, have been settled to some degree. But realizing that in this ethical non-monogamy, we got to keep things in pencil and not pen. Some things are pencil pen, right? There's some hard numbers. But gotta be flexible of what that looks like. So that's why I you talking about being sprung and giddy and all that stuff. I think because those flutters or those emotions, right, those initial thoughts are all kind of new and very much new because this person is brand I've never kind of quote unquote cold called anyone. You know, if that makes sense, because I'm not, I don't think I'm that guy. So, yeah. Thanks for coming to my TikTok. I don't know if I'm going to go in here. Now I'm thinking how far we can go downtown. Because I'm like, it's a lot of folk in there. I don't know if I trust who's in that room right now. Shit. I just need to do better with smoking houses, cigar houses. I mean, I'm just, your opinion matters to me. Because we are in this relationship, but at the same time, you know, like I told us from the outset, I want to be respectful, but I also want to let you know that, you know, your opinion matters. But at the same time, I don't want you to put me in a box, right? Because while we talk about it in theory, this is now the practice part. And with Tab being perfectly fine with, you know, the situation, because how I've handled and been honest and transparent and open with her with regard to this current relationship, me expanding it is not basically she told me, hey, you tell we can talk about it when you think it's worth talking about. But the way that you handle this, I'm fine with it. I trust your judgment because you haven't given me a reason not to. I don't mean, it's a God's way, but yes, we were in Little Run, so we were literally that because it was at that point.
Why she playing out of it?
Like, yeah, nobody at home. Like, this is an exception. I kind of agree with that. But
I'm on skip a little bit.
no, you ain't giving nobody at home.
Gary. He knew how to attract the type of woman that he was looking for. And Latasha, when you got to know her and you got to see all of the details that make her up, she was exactly what he was looking for.
Mm-hmm.
She was so vulnerable because of the happiness being completely drained from her marriage, from the total lack of any emotional connection with her husband of 8 years, the traumatic history that she has had since a childhood, and always being told to keep a good face on. Her history of mental health, depression, suicidal ideations, suicidal attempts, her dependency on other people. He knew that when he got his claws in her, she would do anything to keep him with her, including keeping his secrets. He also knew that Latasha would have to keep his secrets because she had just as much to lose as he did. He had to have someone who was in a good job, with a good appearance, because if they found out about this affair with the pastor, she would lose everything. All of her clients, the life that she had built up in the church, her family's opinion, all of it would be gone. And he reminded her of that. From far away, their relationship, it wasn't a fair. It was absolutely wrong. And it was neither of them took Tabitha's feelings into consideration. Neither of them. And they should have. Tabitha did not deserve that. But especially at the beginning, if you look at that relationship more closely, there was a lot of love there. Latasha built her life around this man. He liked bourbon, so she started learning bourbon. He liked cigars, so she started learning about cigars. She got him into running with her. They joined a biking club together. All of these things that they built. And this woman who came into this relationship so starved for love and affection was receiving it, finally. And she never wanted that to stop. But when you looked at it more closely, you could also see Brutus behaving in a very controlling way, in a very manipulative way. And Latasha was getting slung back and forth between these emotions of, oh, I love you. No, we're going to have some distance. This back and forth, pulling her heart in two pieces. And I will disagree with the state because part of something that they have to prove beyond a reasonable doubt is intent. And one of the things that you have to look at is whether a heat of passion was present. And a broken heart definitely has to do with heat of passion. There is no emotion more powerful in this world than love. When she was with Brodus, Latasha was required to follow certain rules. Rule number 1 that she learned on day 1. You download the Confide app, you use it the way I tell you to, and you only communicate with me in this manner unless I tell you different. Rule number 2, when Brodus took trips, Latasha was expected to be there, and she had to pay her own way, whether she had the money to or not. Rule number 3, Latasha was not to call anybody to come to them, even in the case of a medical emergency. She was supposed to call Pastor Pointer. He knew about their relationship. He would get Brodus help, and nobody would have to find out about Latasha. Rule number 4, Latasha was not to approach him in public. He was only to approach her. Because she didn't have a way of knowing if he was with someone from the church or with another pastor that may not know about their relationship. Very strict rules on what and when she could say to him. Rule number 5, when she was in a hotel room on one of their trips, she was to remain naked. Rule number 6, towards the end of their relationship, Brodus added that she should always respond to him with either yes sir or no sir. And Latasha followed those rules because she loved that man. And she loved the love that she felt like she was getting. And then things changed. On March the 15th, Brodus behaved in a very different way. He treated her like a piece of trash, like someone who was there for his use, not his love, not worthy of his affection. And something in Latasha broke that day. And she decided that she was going to end her life. And yes, she did want him to feel that pain because it was so much pain in her. And she came and never once threatened him. There was never a single allegation that she put him in any danger or threatened him or ever even pointed the gun at him. She actually gave the gun to him once he talked to her for about 2 hours.
Mental.
Brodus knew what to say brings us to April the 4th. Her gun, Brodus had put in a cigar locker in Little Rock. Latasha did not have access to that. She opened did her normal good morning text to Brodus, and finally when he responded, my time has come to an end.
Way too fast.
And it disappeared. And in that moment of disappearing, 2 years of a life, of a relationship, of love was gone. And Latasha was still emotionally fragile from the traumatic experience on the 15th in March. Still suffering from those pains, but trying to work through it. And she decided that she was right the first time. She didn't need to be in this world. She couldn't be in this world. Not anymore. She had built her whole life around this man. And he broke up with her in a disappearing text. She apologized to her family and tried to make them understand that this is not something that she just thought about, that she's been struggling, and that the struggle was just too much. For this deeply religious woman to feel like God couldn't answer her prayers anymore because she was so deep down in this depression is just heart-wrenching. And that was at 3:14 p.m. on April the 4th. I'm having some technical difficulties. There we go. And so, after writing that suicide note, she did go to buy a gun. She didn't have one anymore, and she was going to kill herself. Yes, she planned to go buy a gun. That happened. She did not plan to go buy a gun to hurt anyone other than herself. She walked in, and you heard Mr. Palladino talk on the stand about the range of sizes and weights and prices. If you recall, when he talked about 9mm weapons, he said the cheapest 9mm weapons are in the 200s. He said that the gun that she chose is a small gun. The gun that she chose is a light gun. And when she went to that store on April the 4th, she checked out at approximately 4:47 after going through the background check and clearing it. And if you look, that gun cost $229. She bought the cheapest gun they had and just whatever ammunition they told her to get. Because this was going to be the gun to take her life. So why spend a lot of money on it? After she left the gun store, she went back to her house. She did not want to stay there long. She was afraid her adult son would come home. Poured the bullets out on the bed, grabbed a handful, shoved him in her pocket, shoved the gun in her pocket, and left after leaving him as much money as she could leave him. She got in her car and she started to drive. She was not driving to Memphis, Tennessee. She was driving to Jacksonville, Arkansas, to Johnson Park. This was a place that had particular significance to her because of various names associated with it. British Perry was from Jacksonville, Florida. Her ex-husband's last name was Johnson, and her dad's name was Ray. All of those were men that had hurt her in her life, but that she had also loved immensely. She did not want to commit suicide at home. She did not want her adult son to find her, to have to go through that. She knew that her suicide was hard on him, but she didn't want that weight on him. At that point in time, she believed her son would be better off without him. Come in close to actually analyze them, to see the details that make it up. Tabitha came in to testify, and she talked to you about what she saw on April the 4th and what she experienced. And she was utterly confused by all of this because or going to buy a gun. She then takes a quick trip home and then leaves for the park. Driving down 440, where there's a split for Memphis. She proceeds towards Memphis and arrives downtown, speaks with Brodus for a long time. Latasha then drives to Collierville, sits in the parking lot, calls Brodus, starts to have some second thoughts, and Brodus says, no, go on in. Go on in. Latasha goes to the apartment. Tabitha lets her in. They talk for 10 to 20 minutes. Brodus arrives back home. They talk for 10 to 20 minutes, and then Latasha says, I'm going to leave now. Police respond at 22:36, again, 10:36 Central Time. And by 10:36, Latasha is still standing there with the weapon in her hand. If she left Arkansas at 5 o'clock, and it only takes 3 hours to get to Carterville, why was it 10:36 when police arrived? Unless there was something that happened in between. And we know that there was something that happened in between because Brodus made a video saying, guess who I just saw as I'm walking out of the cigar lounge? All of that corroborates what Ms. Daniels came here to tell you. And I can tell you, sitting on that stand is not easy, especially talking about the things that she had to sit up there and talk about. She's not proud of what she did. She is extremely remorseful for what happened that day. When the prosecutor during cross-examination said, you went there to shoot him, didn't you? She said, no. No, ma'am, I loved him. I would never hurt him. No. That was not my intention. Because she didn't come to Memphis to hurt him. She was planning on hurting herself. And she walked into that apartment happy to be there in the hopes that she would get some semblance of that love back. Very briefly, I'm going to talk to you all about the law. You have your jury instructions.
shouldn't have been, and probably wasn't a huge surprise to her. Monogamous lifestyle. Was she in love? Were her feelings hurt? Had she spent 2 years in a relationship with a married man and she realized he wasn't going to leave his wife? I doubt that. Did she know what she was doing? Yes. And it's unfortunate. It's unfortunate for her. It's unfortunate for Rose Perry's family. Unfortunate for the widow of Rose Perry. She was walking to the door. She reached in her pocket and pulled out the gun that she had brought into their home. She didn't go back out to her car to get the gun. Was it for protection from her car to the door, or did she forget it was there? We heard both sides of that story. And she shot him 7 times. And killed him. How can that not be intentional and premeditated? Even disregarding all the evidence except what she tells you, how can that not be intentional and premeditated? Especially considering Dr. Biting's testimony. And all the things she did. Tabitha got away. Not pointing the gun at the police. Not harming herself. Where was this total loss of judgment? She was hurt. She was mad. She was embarrassed. She didn't like what Brodus had done to her. What Brodus had done to her. I ask you to follow the law. Apply the evidence to her, to it. And if you do that, I submit you'll find that she's guilty. Thank you.
Verdict, y'all.
Do I need to start from state of Tennessee versus?
Come to verdict.
Yes. Is that your verdict? Is that your verdict? Yes. Is that your verdict? 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 Is that your verdict?
Yes.
Is that your verdict?
Hold on. I didn't hear it. Let me see it. Let me take it back.
We, the jury, find the defendant not guilty in count 3 of indictment number 25-01253.
Told y'all.
Would you like the jury poll? Yes, please. Okay. I'll start on this end. Is that your verdict?
I told y'all she was going to be found not guilty because he played games with her.
Is that your verdict? Yes. Is that
It could have went anyway. I told y'all.
Is that your verdict? Is that your verdict? Is that your verdict? Yes. Is that your verdict?
Yes.
Is that your verdict? Yes. Is that your... Now that you have concluded your service on this case, I thank you for your patience and conscientious attention to your duty as jurors. You have not only fulfilled your civic duty, but you have also made a personal contribution to the ideal of equal justice for all people. questions about the confidentiality of the proceedings. Because the case is over, you are free to discuss the case with any person you choose. However, you do not have to talk to anyone about the case if you do not want to.
Mm-hmm.
If you tell someone you do not wish to talk about it and they continue to bother you, let the court know, for we can protect your privacy. If you do decide to discuss the case with anyone, I would suggest you treat it with a degree of solemnity, so that whatever you say, you will be willing to say in the presence of your fellow jurors or under oath here in open court in the presence of all the parties. Also, if you do decide to discuss the case, please respect the privacy of the views of your fellow jurors. Your fellow jurors fully and freely stated their opinions and deliberations with the understanding they were being expressed in confidence. Again, I thank you for your willingness to give of your time away from your accustomed pursuits and faithfully discharge your duties as jurors. You are now excused. I will be back to speak with you shortly, so I'll show you excused to the jury room. Miss Daniels, you will please stand. A jury of your peers has found you guilty of second-degree murder in count one. The jury has found you
Hold on.
guilty in count two of reckless endangerment, and the jury has found you not guilty in count three. As a 13th juror,
Wait a minute. Hold on. Let me back that up. Hold on. Cause I said that some stuff she can be guilty and not guilty too. And second degree. That's what I said, second degree. They found you guilty of second degree. That's what I said. And
murder in count one. The jury has found you guilty in count two of reckless endangerment, and the jury has found you not guilty in count three.
told you.
As a 13th juror, I approve that verdict. Will show your bond revoked and will show this matter set for sentencing.
Thank you.
And see, you and I said that.
January the 12th.
We'll need to do a pre-sentence report. If we could get a shorter date to get the pre-sentence report back.
But you know what? You and I said that it could go either way. It can go not guilty for something and guilty for something. And I say second
We don't have to reset it once we get
degree of manslaughter
We can reserve January the 12th.
But just get a
instead of first degree.
report.
I actually hoping to be in Colorado.
On January 12th. Okay.
That was interesting.
December date and then pick a date this one.
Okay, so what y'all got to say about this? Cause this it. Until they're gonna come back in January. But this was interesting. It turned out interesting because second degree. That's what I wanted her to get. And some stuff I didn't find her guilty, and some things I found her guilty. But I'm glad that y'all watched the trial, and I hope everybody learned, from their decision. And I want to say, Verdi, Vitter, you did an awesome job as I've been checking you out. An awesome job as a moderator as today. Now that was awesome. How you took control of the chat instead of me talking, you talk. I want to tell you that you did an awesome job. You did an awesome job. And I appreciate everybody. Like, share, and subscribe. Enjoy your Friday. And I'll see y'all soon. I'm out of here.